the Australian Law Students Association Red Cross International Humanitarian Law Moot Competition Grand Final. Could we ask for appearances, please?
Your Excellencies, my name is Campbell, initial M, and I appear alongside my learned co-counsel, Svensson, initial L, on behalf of the prosecution in this matter. We will each be speaking for 19 minutes, with 2 minutes reserved for rebuttal. May it please the tribunal.
Thank you, Mr. Campbell. Could I ask you to repeat your junior's name? I didn't catch it.
Svensson, initial L.
And how do you spell the surname?
S-V.
Yes.
E-I-N.
E-I-N.
Double S-O-N.
Thank you.
May it please the court, my name is Bunting, B-U-N-T-I-N-G, and I appear with my learned junior, Bowes, B-O-W-E-S, in this matter for the defence. I will speak to count 1 and my learned junior to count 2, each speaking for 19 minutes, reserving 2 minutes for rebuttal. May it please the court.
Thank you very much, Ms. Bunting.
Yes.
Thank you, Mr. Campbell. Yes.
Your Excellencies, this case concerns 2 individuals who committed serious violations of international humanitarian law that resulted in the substantial loss of civilian life. It is the purpose of international humanitarian law to draw the line between what is unavoidable amidst the chaos of war and what cannot be acceptable under any circumstances. The conduct of General Byrd and Professor Klaus crossed this line. We, the prosecution, submit that there are 3 things that must be established in order to successfully prosecute both General Byrd and Professor Klaus. First, that this court has jurisdiction to consider this matter. Second, that war crimes did in fact occur. And third, that General Byrd and Professor Klaus are responsible for the occurrence of these war crimes. I will be dealing with the matters relating to jurisdiction and with the existence of war crimes and responsibility for them in relation to count 1, and my co-counsel will be addressing the existence of war crimes and responsibility for them in relation to count 2. May it please the tribunal.
Mr. Campbell, we've read the written submissions of both sides and we understand from them that your opponents do not contest the question of jurisdiction. In those circumstances, the court having no particular problem with jurisdiction, we think that you can, it would be unnecessary for you to address that issue.
Yes, Your Excellency, we do note that the defence have not contested anything substantive in relation to jurisdiction, and if it is the wishes of the tribunal, I will then move immediately into our first submission in relation to count 1.
Thank you.
Your Excellencies, we submit that the incidents relating to the humanitarian aid convoys amounted to a war crime pursuant to Article 8(2)b, Roman numeral 25 of the Rome Statute, which outlines that intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, as provided for under the Geneva Conventions, is a war crime. Your Excellency, there are 4 elements which must be established in order to make out this war crime. The first 2 of these, that the conduct took place in the context of an international armed conflict and was associated and that General Byrd and Professor Klaus were aware of the factual circumstances that established the existence of this armed conflict, is not contested, and so I will be addressing the second 2 of these elements. And these are that, first, civilians were deprived of objects indispensable to their survival, and second, that the perpetrator intended to starve civilians as a method of warfare. Your Excellencies, both of these elements can be established. Turning to the first of these elements, we submit that civilians were deprived of objects indispensable to their survival.
Before you go on to that, could you help us with the source of your elements? From which source do you draw the elements that you've just articulated?
Your Excellency, these elements are drawn directly from the elements of crimes, which establish the elements required to establish a war crime for the purposes of 8.2b, Roman numeral 25 of the Rome Statute.
Thank you.
Your Excellency, the defences argued in paragraph 6 of their written submissions that the BDF had the right to search and to prescribe such regulations, under which passage was allowed pursuant to Article 70, subsection 3c of Additional Protocol 1 to the Geneva Conventions. However, we would submit in response to this that Article 3c outlines that this entitlement to delay convoys is only enlivened in cases of urgent necessity in the interests of the civilian population. We submit that delaying the convoys was not a matter of urgent necessity that was in the interests of the Sikalari population. Your Excellencies, these convoy delays resulted in over 115 recorded deaths.
Excuse me, Counsel, just can I stop you at that point? Is it ever okay then for a military force to impede or delay relief supplies at all?
Yes, Your Excellency. Article 70 does permit for the delay of convoys in circumstances where the occupying power has concerns that these these convoys contain such items that are being misappropriated or might afford a party a direct military advantage.
And is that not the case here with the weapons that were found in the convoys? The suggestion that there was misappropriation later of fuel supplies.
Your Excellency, I will address your question with 2 points. In regards to the fuel, we would draw the Tribunal's attention to the fact that we only have the assurances of the BDF in regards to the weapons, that weapons were found in 2 of the convoys, whereas we have the words of Humanitarian International, which was a well-acclaimed international aid agency, that there were no such weapons within these convoys. We also have evidence that 15 convoys were rejected on the basis of containing military equipment when there was no such indication that this was actually the case. In regards to the fuel, we would submit that even if the BDF did have concerns that this was being misappropriated, they could have still provided an escort to provide fuel to the hospital where it was being used for humanitarian purposes. And we would submit that a blockade of 3 weeks in which all of the aid was blocked would not justify the actions of the BDF in this regard.
Thank you.
Further, Your Excellencies, I wish to draw your attention to the fact that before this conflict, Sikalari was a town of 10,000 civilians. Consequently to the BDF's invasion of Sauzumba, 20,000 civilians then flooded into the town, which caused Sikalari to become a town that was at breaking point. Therefore, it was not in the best interest, and it was not a matter of urgent necessity for the BDF to impose a blockade of 3 weeks. It was devastating, and therefore the defence cannot argue that Article 70 and the rights prescribed within justified their actions, as this was not regulated access that was in the best interest of the Sikalari civilians. Indeed, if the BDF did have the best interests of the Sikalari civilians in their minds, they would have allowed for the provision of some aid during those 3 weeks. But on the facts, we have the fact that there was no aid allowed during these 3 weeks, and therefore the defence within Article 73C is enlivened, and that the actions of the BDF cannot be sanctioned within the rights prescribed within this section.
Assuming that we were to find that, in fact, some of the convoys contained fuel as part of the load, and some, as is alleged by your opponents, contained weapons, how should we approach, given those findings, the arguments that you just put?
Your Excellency, if it was found that that the fuel was solely being used for the purposes of affording a direct military advantage to the BDF, then the BDF would have been permitted to act as they did. However, it is the prosecution's submission that as the fuel was also being used to provide energy for the 2 hospitals, which was being used to treat the starving Sikalari civilians, that the prosecution cannot rely on this for the purposes of their submissions.
Thank you, Mr. Campbell.
Your Excellencies, I will now turn to the second element of this war crime, in which we submit that the BDF did intend to starve civilians as a method of warfare. Your Excellency, intent may be inferred from the relevant facts and circumstances. We submit that intent in this situation can be inferred from a number of facts and circumstances within this case. Firstly, when Humanitarians International gave their assurances that no weapons were contained within the convoys, the BDF willfully impeded the convoys anyway. When 15 military convoys were turned away on the basis of containing weapons, when later it was found out that there was no such indication this was actually the case, they willfully impeded the convoys anyway. When conflicting reports and rumours spread about the misappropriation of this aid by the FNA, the BDF willfully impeded the provision of this aid for 3 weeks, and that further, the intent of the BDF can be drawn from the fact that they took no proactive measures during this 3 weeks to provide any such aid at all, and that they were still in a position to provide the Sikalari citizens with such food and water which was adequate to prevent them from starving. Clearly, Your Excellencies.
What do you say the definition of starvation is? Because your focus in this case needs to be on starvation, I think, as opposed to the willfully impeding the convoys. So my question is twofold. How do you define starvation, and what's the causal nexus between intentionally using starvation as a method of war and the impeding of convoys in this case?
Your Excellency, we do appreciate that distinction, and we would define starvation as a method of warfare exists where the perpetrator's purpose is to deliberately use starvation to gain a military advantage through the annihilation or weakening of a population. And Your Excellency is correct, the proper test in regards to intent, the emphasis is on intent to use starvation as a method of warfare as opposed to the deprivation of objects indispensable to survival. And so we would argue that this inference can be drawn that starvation was intentionally used as a method of warfare, because during this 3-week blockade, the BDF was still in a position to provide such adequate food and water so as to prevent starvation, but it took no proactive measures to do this. It imposed a blanket blockade of all aid for 3 weeks, and that this should be sufficient for this tribunal to draw intention that BDF intended to use starvation as a method of warfare.
And where do you draw your definition of starvation from?
Your Excellency, this definition is drawn from commentary on Additional Protocol 1 to the Geneva Convention.
Thank you.
Your Excellencies, I will now turn, as all of these elements have been established pursuant to Article 8 2b Roman numeral 25 of the Rome Statute, we have established that the war crime of willfully impeding aid relief supplies and starving civilians did in fact occur. Consequently, I will now turn to our submissions regarding who is responsible for the occurrence of this war crime. We submit that it is General Byrd who is responsible for this war crime, pursuant to Article 28A of the Rome Statute, because the requirements of command responsibility in this case can be met. Your Excellencies, there are 4 elements required to establish that command responsibility existed and that liability can be attributed to General Byrd. These are that first, General Byrd exercised effective control over the British forces. Second, that the crime resulted directly from General Byrd's failure to exercise control over the British forces. Third, that General Byrd did not use necessary and reasonable measures to prevent the occurrence of his subordinates committing the crimes. And fourth, that General Byrd had actual knowledge or reason to know that crimes had been or were about to be committed by his subordinates. Turning now to the first element, we submit that General Bird is individually responsible because he was in effective control of both the lines of AQUAS and the BDF at the time of the events. To establish effective control, it is sufficient to prove that there was a relationship of subordination and that General Bird had the material ability to prevent or punish crimes that were committed. Your Excellencies, General Bird served as the highest ranking officer of the BDF during the years 2012-2013. The lines of AQUAS operating in the area were under the direct command of the BDF. All HIA convoys which were stopped in the area were also stopped by the lines of AQUAS and BDF, and therefore the chain of command controlling convoy approval is clear in this case and effective control can be established. We note that the defence may argue that General Bird did not exercise effective control over the lines of AQUAS on the basis that he may be identified as a de facto commander. However, in response to this, we would argue that de facto commanders can still exercise material ability to prevent or punish subordinates from committing a crime. It was outlined in the case of the prosecutor and Tiamir Blaskic that what matters is their material ability, and that material ability extends to such things such as submitting reports to the competent authorities in order for measures to be taken, regardless of whether or not this tribunal decides that General Bird was a de facto or a de jure commander. The prosecution argues that regardless of this categorisation, he did still have the material ability to punish or prevent the crimes of both the lines of AQUAS and the BDF.
Is there any evidence that General Bird knew that these activities were occurring?
Your Excellency, in regards to the fourth element of command responsibility, we are submitting that General Bird did have reason to know that his subordinates were impeding the aid convoys.
Thank you.
Your Excellency, I will address this fourth element now. So it is sufficient, to answer Your Excellency's question, to prove that a superior had access to information that indicated a need for further investigation or put them on notice of the fact that crimes had been or were about to occur. It is the submission of the prosecution that General Bird had access to the prolific media reports covering the incident by both the Sikalari Times and the Human Rights Observatory, and that this information put him on notice of the possibility of crimes being committed, and that he should have conducted further investigations into this possibility, and that this is sufficient to satisfy the knowledge element required. Your Excellency, turning now to the second element, we submit that the crime resulted from General Bird's failure to exercise control over the pernicious forces. We submit this element of causation can be satisfied because if General Bird had taken such reasonable and necessary measures to prevent the crimes, the starvation of the Sikalari citizens would not have occurred. Turning now to the final element of command responsibility, we would submit that General Bird did not use necessary or reasonable measures in order to prevent these crimes from occurring. Necessary measures, Your Excellencies, are those which are required to discharge General Bird's obligation to prevent or punish crimes from being committed, and reasonable measures are those in which General Bird was in a position to take at the time. Your Excellencies, we would submit that it would have been reasonable for General Bird to have allowed for the provision of some aid which was adequate to prevent the starvation of the Sikalari citizens during the 3-week blockade. This would have been a necessary measure, and General Bird did not take this measure. Furthermore, General Bird could have taken necessary measures to expedite the approval process upon finding out the direty of the situation facing the Sikalari citizens. There is also the fact that General Bird did nothing on the facts to punish the crimes that were committed. Nothing on the facts suggests that subordinates were ever punished. No inquiries were made, no reports were submitted, and no disciplinary measures were taken. And therefore we can comfortably establish that General Bird did not take reasonable or necessary measures when he was in the position to do so. We appreciate that General Bird was geographically remote from the conflict, but this does not negate his ability to initiate orders which could have instigated these disciplinary measures.
Counsel, I just wanted to pick you up on that issue of the geographical remoteness from the actual crimes. Does this absolve him of any form of responsibility, and is there a citation we can rely on that says this is an irrelevance?
Your Excellency, I note that my time has expired, so I would request a brief minute extension to address your question.
Yes.
Your Excellency, in regard to geographical remoteness, we would refer this tribunal to the authority of the prosecutor and against Timur Blaskic, in which at paragraph 302, it is noted that what matters is the material ability of the commander to punish, and that this material ability extends to such things such as submitting reports and making inquiries as to investigation. And so even if this tribunal finds that General Byrd was geographically remote from the conflict, this does not negate his ability to submit reports to his subordinates so that they could have taken these disciplinary actions for him.
Thank you.
I'll just ask you to pause a moment and we'll suspend time for a moment. I wasn't sure whether that knock meant that you had 1 minute left or whether your time had expired.
1 minute left.
So you had 1 minute left anyway. So the first knock indicates you have 1 minute to go. We'll take all that into account now that you can restart
Thank you, Your
with whatever
Excellency.
time you've got left.
In conclusion, we submit that it is clear that a war crime occurred and that General Byrd is responsible for the occurrence of this war crime in relation to count 1. This tribunal must prosecute General Byrd and hold him accountable for the atrocities that were committed under his watch. Unless the tribunal has any further questions, my learned co-counsel will continue with the submissions for the prosecution.
Thank you, Mr. Campbell. We have no further questions. Thank you, Ms. Svensson. Yes.
Your Excellencies, I will address the second count in establishing that Professor Klaus is criminally responsible for war crimes in overseeing the launching of drone attacks against the citizens of Flyland on the night of the 4th of February 2013. To this point, I will make 2 key submissions. First, that the launching of drone attacks causing loss of life and injury to civilians was a war crime, and second, that Professor Klaus is criminally responsible for these actions. Moving to
Counsel, sorry, before we get started, the big thing for me here is that Professor Klaus appears to be a civilian. How do we get over that in terms of prosecuting somebody for a war crime if combatants are the ones that should be held responsible?
Your Excellency, there is precedent to establish that civilians can be held accountable for such crimes, particularly in the International Criminal Tribunal for Rwanda, drawing Your Excellency's attention to the cases of the prosecutor against Akayesu and the prosecutor against Kayashema, respectively, both of which were civilians who, by virtue of their actions within the Rwandan genocide, were able to be charged by that court with crimes against humanity and war crimes. Further, it was noted in Akayesu and the prosecutor, where the accused was a former teacher and public official, identically to Professor Klaus. The appeals chamber expressly rejected the argument made by the prosecution that de facto military command was necessary for a civilian to be charged by that particular court, noting that what was necessary was only that there was a specific nexus between the acts that were committed and the conflict as a whole.
Thank you.
Moving to our submissions regarding the fact that a war crime did occur, namely intentionally launching an attack in the knowledge that such an act would be expected to cause incidental loss of civilian life or injury to civilians, such as would be clearly excessive in relation to the concrete and direct military advantage. Your Excellencies, we turn to the elements of crime of the Rome Statute, which we note in paragraph 1 of the facts should be taken into consideration by this particular tribunal. 5 elements must be present in order to establish that this violation has occurred, and as we note that the defence do not contest that this incident occurred in the context of an international armed conflict, or further that Professor Klaus had knowledge of such circumstances, I will address the remaining 3 elements. namely that attacks were intentionally launched. Secondly, that these attacks caused or were such as would cause excessive loss of civilian life. And thirdly, that Professor Klaus had knowledge of such.
Yeah, you need to go further than excessive loss of civilian life, don't you?
I apologise, Your Excellency, I paraphrased for the sake of clarity. It needs to be clearly excessive in relation to the concrete and direct military advantage anticipated.
And the word clearly is missing from the indictment. Are we to, or does the prosecution accept that you need to establish that it was clearly excessive as opposed to merely excessive?
In relation to the word clearly, we would submit that this should not be seen as changing the standard which should be applied by this particular tribunal. And we would draw the panel's attention to the fact that the ICRC in its commentary has repeatedly stated that the word clearly is not intended to change the threshold or the standard of proof which must be accepted. And further, that as the ICRC is a well-respected commentator and its comments are seen as forming a part of customary international law under Article 21(1)b of the Rome Statute, that should be taken into account.
Thank you.
Your Excellencies, we note that counsel for the defence in their written submissions argued that these were not attacks intentionally launched and that they did not constitute acts of violence. However, Klaus and his students intentionally launched drone attacks by initiating the drone strikes. Now, attacks are defined.
Sorry, Counsel, are we talking about both attacks? Are we referring to the first attack against the school, but also the attack which occurred apparently when there was a malfunction? Are we saying both of those were intentionally launched?
Yes, Your Excellency. For the purpose of maintaining time, I will address both attacks together. However, we would contend that both attacks individually would constitute a war crime. The intention behind the first attack is not contested. However, the defence have contested the fact that the second attack was intentionally launched or was an act of violence, as is the definition of an attack under Article 49(1) of Additional Protocol 1, in contesting that Professor Klaus was in control of the drone at the time. However, it is evidenced in statements in paragraph 14 and 15 of the facts, stating that the team provided numerous commands to the drone as it was flying towards the civilian area, including to launch missiles, that the circumstances did amount to the intentional launching of an attack. The fact that the team may have attempted other commands unsuccessfully at the time does not negate the intention to launch this attack.
Is it your case that the act of taking control of the drone was sufficient to constitute the launching of an attack, even though they subsequently lost control of it?
Your Excellency, we would contend that actually taking control of the drone does not constitute an attack, as an attack under Article 49(1) must be an act of violence, and so merely taking control would not constitute such, but that the latter launching of a missile, and it is noted at paragraph 15 that Professor Klaus and his students issued commands for the drone to launch missiles at this time, does fall within
In
that
respect of the
definition.
school, yes, but in respect of the second attack, you say, what were the acts that the accused engaged in to make that an attack? Because it seems on the facts that they lost control of it.
If I could draw Your Excellency's attention directly to paragraph 15 of the facts, it is stated that the team issued a number of controls or commands to the drone,
Yes.
including to turn it, to land it, and to launch its missiles. And it is our contention that even if Professor Klaus and his students were not aware of whether this missile would or would not be launched, the fact that they issued that command itself amounts to an attack within this definition.
So even though those commands were unsuccessful, and it's stated in the facts that all of those commands were unsuccessful, it's the actual engaging with that.
That is correct, and as will be noted later, the commission of an offence requires that the perpetrator take the physical acts which are required, which has been established in the circumstances. Moving to the next element, Your Excellencies, that these attacks were such as would cause loss of civilian life, injury to civilians and damage to civilian objects, which would be clearly excessive in relation to the concrete and direct military advantage anticipated. While we do appreciate the difficulty in weighing up proportionally military advantage and human lives, as has been established again and again in the international criminal tribunals for the former Yugoslavia and for Rwanda, We would submit that in this case, this balance should be struck in favour of the prosecution, as firstly, minimal military advantage was anticipated as resulting from these strikes. Secondly,
Counsel, sorry, can you explain to me what minimal must be then if the removal of 150 troops and a place where they're sheltering is not significant? How do you measure it?
unfortunately, Your Excellency, the primary difficulty with establishing this particular count is that it is extremely difficult to quantify. However, it is noted in ICRC commentary to Additional Protocol 1 at paragraph 2024 that this advantage must be substantial, and we would submit that the loss of life of some 50 personnel in the context of a large-scale state-to-state international armed conflict does not qualify as substantial. Further,
Do we have some case law that would actually, rather than commentary, do we have case law that substantiates that or makes a measure?
there is minimal consideration of this particular issue, Your Excellency. Perhaps the most authoritative case is that of the prosecutor against Galich in the International Criminal Tribunal for the former Yugoslavia. However, it should be noted that in that particular case, a decision was not made in regards to proportionality, as it was found that the distinction principle had been breached in that particular instance, as the ones perpetrating the attack could not see their target. However, there it was thought that the casualties incurred from that were some 13 or 14 people, and that was seen as disproportionate. We understand that there is a factual difference between the two here.
Okay, thank you.
We would further submit that as such military advantage must be definite rather than potential or indeterminate, and must be foreseen by the perpetrator at the relevant time. The damage to the school, which had on the facts no particular tactical significance other than its use as a shelter, should not be seen as a substantial military advantage. Further, as
But why shouldn't destroying something that's being used by the enemy for military purposes be seen as being a significant military advantage? Because you've destroyed something that they're using and destroyed a large number of their troops.
Your Excellency, we do not contend that this was not a military objective, but in fact by virtue of its use as a shelter it was. However, it is our contention that it was not a significant enough military advantage to outweigh the civilian casualties, given that we are not sure that there weren't several different buildings in the area which could have been used for the same purpose. And further, given that this particular advantage must be definite rather than simply potential, that this shouldn't be given a large amount of significance. Further, the defence cannot rely on any potential disruption of the FNA's drone system or avoidance of any kind of attack against British territory as a particular military advantage, as this too relies on speculation, as it is not known what the particular purpose of that drone was at this time. While we appreciate that the target of the second attack, that is a large military base of the FNA, would have been considered a significant military advantage, this tribunal must also consider the anticipated likelihood of that military advantage being obtained, as is reinforced in Articles 57.2 of Additional Protocol 1 and the case of Ergi against Turkey in the European Court of Human Rights. Now, in this case, given that particularly unfamiliar drone technology was being used by inexperienced personnel, that should be taken into account by this tribunal in noting that it is unlikely that that particular military advantage would have been obtained in the circumstances. Further, in tempering this particular balance, Your Excellencies, we would note that the civilian casualties which could be expected to result from these attacks were significant. Your Excellencies, this target was located in a civilian area in close proximity to recent bombings which could be expected to cause displacement. And while the school was a military objective by virtue of its use, Professor Class was still obligated under Article 57.1 of the Additional Protocols to take all feasible precautions to ensure that there were no civilians present in the area. Your Excellencies, there is no evidence on the fact of any precautions being taken to this particular account.
Is that right? He's going to take all steps to make sure that there are no civilians in the area?
Under Article 57.2 of the Additional Protocols, he must take all feasible precautions to ensure that the target is not a civilian object or does not involve civilians, and that if there is a chance that this will not be the case, the attack must be cancelled. We do appreciate that this should also be tempered by the fact that under Article 58 of the Additional Protocol, the FNA had a positive obligation to remove civilians from the area. However, referring the tribunal to the case of the prosecutor in Gallup at paragraph 61 was noted that failure of a party to abide by this obligation does not relieve the attacking side of its duty to abide by the principles of distinction and proportionality and to take proper precautions when launching an attack.
Counsel, no, the word feasible. What feasible precautions could he have taken in this situation?
It is our contention that as this was planned over a number of months, it's noted that it was 2 months since the initiation of their attempts to launch this particular attack. Professor Klaas had ample time to identify a target which would have been distinct from any particular civilian objects or the chance of civilian casualties. Further, as Professor Klaas was in regular contact with members of the military, it is noted that he was in contact with these every Monday, and that the 4th of February of 2013 was a Monday, so mere hours before. He could have obtained intelligence from these military officials to understand the precise situation in the area and whether any civilians could be expected to be in the proximity of military objectives.
Counsel, these meetings though, they're not sort of formal military meetings that he was undertaking. He's meeting a bunch of his friends in a pub.
We do note that these were not formal military meetings. However, it is noted at paragraph 12 of the facts that at these particular meetings they discussed issues of military significance. Officers who reported directly to General Byrd and can be then understood as having a large amount of knowledge about the circumstance revealed highly classified information in regards to the conflict. And so this should not be seen as analogous to a standard meeting at the pub, Your Excellency.
Thank you.
Finally, these later submissions also go toward the element of knowledge which must be established, that being that in determining the foreseeability of loss, the tribunal must consider whether a reasonably informed person with the information available to him, making reasonable use of that, would expect that incidental loss of civilian life or injury would result. It is our submission that given Klaas had previous military experience, that he was working with students who had extremely limited experience with this particular technology, that the technology was unfamiliar technology which had not been tested, and that he had these particular connections. With the use of the information available to him, Klaas would have known, or should have in the circumstances, that this damage would be clearly excessive.
Would you distinguish between these two cases? On the one hand, a missile is launched after every precaution is taken to ensure that the missile, when launched, will operate according to its design characteristics, and that its target is a purely military target. But without any blame attaching to those who launched the missile, it inexplicably misses the military target and hits a civilian target. That's one case. The other is a case more like the one we have here, where the drone, as you would argue, was one that Klaas ought not to have accepted would do its job in accordance with its specifications. Are those two cases different?
Excellency, we would contend that those cases are different, and that the primary difference is the failure to take precautions, which was apparent in this particular case. If Klaas had done all that was reasonable for a person with his experience and knowledge to ensure that this target, that the technology would work as would be intended, and that the target was not in proximity to a civilian object, not just that it was not a civilian object, we would contend that that would be different and may swing that balance. However, that is not the case here, Your Excellency.
Thank you.
Moving finally to establishing the criminal responsibility of Professor Klaas, we would submit that first, Professor Klaas is individually responsible under Article 7.1 of the Statute of the International Tribunal, and in the alternative that Klaas is responsible under Article 7.3 by virtue of the actions of his students. And Professor Klaas is responsible under Article 7.1 of the statute, as it is specifically stated at paragraph 14 that he with his team committed the attacks by launching the missile directed at the school. which fits the physical perpetration test outlined in the case of the prosecutor in Tadich in the ICTY. While we would accept that there is further ambiguity in leading to who was responsible for the physical perpetration of the second attack, we would submit that in this case, Professor Klaas aided and abetted in this strike by carrying out acts which were specifically designed to assist, encourage, or lend moral support to the enterprise, which had a substantial effect on the perpetration of the crime. Your Excellencies, this could not have occurred without the assistance of Professor Klaas, his connections to the military, and his facilitation of training for the students. And further,
You have 1 minute left.
thank you. Further, as was noted in the prosecutor against Struger in the ICTY, the knowledge element required for such is the knowledge that these actions will lead probably to the contribution of the commission of a crime. And it should be noted that with Professor Klaas's knowledge, commission of a crime should have been considered probable. In moving to Article 7.3, Professor Klaas, in the alternative, is responsible by virtue of the actions of his students, as both attacks were committed by the student team, and the students were subordinates of Professor Klaas. He exercised a control over them that was analogous to military control, and in this case it should be seen as that being sufficient to establish command responsibility, meaning that he had material ability to prevent or punish. Your Excellencies, I note that my time is near expired.
One last question as to whether a university professor seriously has control over his students at all.
While that might be contested by some university professors, Your Excellency, I would draw your attention to the case of the prosecutor and Alexowski in the trial chamber of the International Criminal Tribunal for the former Yugoslavia, where they cautioned that paragraph 78 that while civilian authorities are superiors if they exercise a degree of control with respect to their subordinates, similar to that of a military person in an analogous position, these civilian sanctioning powers and control over those subordinates must be interpreted broadly, and so as to ensure that this doctrine is not made so narrow as to prevent any kind of prosecution of civilians acting in de facto control over subordinates. May I ask a brief 20-second extension to conclude our statements? Your Excellencies, both General Finlay, Bird and Professor Klaas are criminally responsible for serious violations, both of which led respectively to the deaths of numerous civilians and directly contradict long-established principles of just conflict. Consequently, the prosecution respectfully submit that the tribunal must prosecute both individuals for these violations under the jurisdiction given to it under Articles 1, 3 and 7 of its statute. If the panel have no further questions, that concludes the submissions for the prosecution.
Thank you, Ms. Svensson. Ms. Bunting.
May it please the Court. Your Honours, the defence will show that it cannot be proved beyond reasonable doubt that either General Bird or Professor Klaas committed the alleged crimes. Your Honours, in speaking to Count 1, I will be making 3 submissions. We note that the issues for determination are those contained in the Rome Statute's identical provision of Article 8, 2b, Roman numeral 25, and that the defence does not contest either the existence or awareness of an international armed conflict. Rather, we will make submissions on the issues upon which this case turns, being first, that there was no deprivation of objects indispensable to the survival of the civilian population, and even if there was such deprivation, that it was not willfully done. Second, that there was no intention to use starvation as a method of warfare. And third, even should the elements of crime be made out, that criminal liability could not be attributed to General Bird on the basis of command responsibility under Article 28 of the Rome Statute.
Ms. Bunting, may we say, in case I forget to say it later, that we do appreciate your giving away or making the concessions that you've made. We think they're appropriate, and given that they are appropriate, we appreciate the fact that you've made them.
Thank you, Your Honour. The defence notes that the prosecution bears the burden of establishing the guilt of the accused beyond reasonable doubt, as provided for under the Rome Statute's Article 66(3). In turning to our first submission, that the British forces did not deprive civilians of objects indispensable to their survival through the impediment of relief. Impediment will only occur where there are no legitimate grounds for interference in the free passage of relief. Your Honours, with respect to our learned friends, they appear to have conflated the grounds of exception. Delay requires no misappropriation or military advantage. It is an impediment because it operates against the positive duty under Article 70 to facilitate the rapid distribution of aid, which we would submit in the present circumstances is not made out. In fact, at paragraph 27 of the facts, it states explicitly that the length of the time of the searches was directly in relation to the size of the convoys and was thus not excessive nor causing undue delay. Your Honours, in relation to the issue of whether or not weapons were found within the convoys and the refusal of the 15 convoys, which had been a contentious issue in our learned friend's argument, the facts do state that it was only a statement of the BDF that weapons were found within the convoys, and as such may amount to the drawing of an adverse inference as per prosecutor in Blaskich. However, the preconditions for the reversal of the burden of proof is that only one party has access to relevant evidence. In the present case, both the BDF and Humanitarian International had the access to that information, and as such the exception cannot be invoked and the normal standard should apply, being beyond reasonable doubt. Elsewise, Your Honours, we would engage in a pointless battle of he said, she said in relation to whether or not there was material arms within the convoys. On the basis that it cannot be proved beyond reasonable doubt that the aid was impartial in nature and that weapons were contained to the best of the BDF's belief within those convoys, it is open to the BDF to refuse free passage, as per Article 71, free passage will only arise where the relief is solely humanitarian or impartial in nature. Where there is a belief on the part of the BDF that the convoys did include some military weapons, this would not amount to legitimate impartiality, such as to give the convoys the protection of these articles. Moreover, we would rely upon the two instances where the convoys refused to undertake the search procedures of the BDF as casting doubt as to whether those convoys were exclusively humanitarian in nature.
Councillor, can I just stop you there? If you're saying that there was a question for the BDF as to whether or not the aid convoys were humanitarian and impartial in nature, is there no obligation on the BDF to fill the gap?
Well, Your Honour, we would submit that the filling of the gap, that burden lies with the occupying power, and that was the state of Flyland. An occupying power will be that power who has effective control of the area, and from the evidence that a Flylandian military base was operating in Sikalari, that the soldiers had access to different parts of it, and it seems that there was an effective government within that area that was Flylandian. They have that burden upon providing the relief. The burden upon the opposing party is only to facilitate that relief, but not to ensure that it is acquired by the civilians themselves.
But in a siege situation, I'm trying to work out how the Flylandian forces within this besieged area can facilitate the distribution of aid if it's being blockaded.
Your Honour, there's no necessary evidence of the fact that the BDF had exclusive control over who could enter or exit from Sikalari, merely that the humanitarian aid convoys entered Sikalari through an area that was controlled by the BDF. And given that Sikalari is within the Flylandian National Territory, it cannot be presumed that there was only one entrance into Sikalari. In fact, there is evidence on the facts, and when the trucks were destroyed, that they were coming from an alternative route. There were multiple entrances that they could have entered into Sikalari. It was not a blockade or siege situation, but merely that their passage to Sikalari in the present circumstances went through British territory.
But if that was correct, this wouldn't have happened. The convoys would have just gone through a different way. So it must have been a siege.
Well, Your Honours, we don't have evidence on the facts as to whether or not there was a siege. We can merely infer from the circumstances as they exist to us. And what we can see is that they must have entered into some sort of agreement with the British forces to permit aid to enter into Sikalari, even though they were not the occupying power. even though they did not have exclusive control over the city and responsibility to its civilians. They were letting aid go through to enemy forces' civilians.
Thank you.
In relation to the intercepted message that the line should not let supplies enter at all, no weight should be given to this supposed evidence because it is disproved on the facts. Relief convoys were allowed to enter Sikalari, and as such it is not sufficient to put the court on notice or some design on the part of the BDF to deprive civilians. Your Honours, in relation to the two circumstances where all aid was refused, this is legitimate where the party refusing the relief has serious reasons for fearing misappropriation of supplies or that a definite advantage has accrued to enemy forces. As relates to the complete suspension of relief, it occurred first following evidence that the fuel was being misappropriated by the FNA soldiers and that sale of aid supplies on the black markets was amounting to an appreciable economic advantage. And secondly, following the destruction of two relief supply trucks in June 2013. Admittedly, the difficulty that the defence must address is that this aid was refused where the circumstances in Sikalari were dire and where the refusal as such entirely prevented any aid from reaching the civilians. However, such refusal was necessary in the circumstances and so justified.
What was the necessity to completely halt the supply of this emergency relief for 3 weeks?
Well, Your Honours, we have evidence on the facts, firstly, that the fuel supplies were being used by the FNA military to supply their vehicles. Secondly, that the supplies were being appropriated and sold on the black market. And third, and most damagingly of all, a Human Rights Observatory report stated that even though convoys were entering the Sikalari area, that their situation was not improving. What we can see then is that the majority of supplies were being appropriated for use by the FNA soldiers. And as such, and as stated in paragraph 31 of the facts, the reason that the BDF put forward as to denying the passage of aid is declared that it was a temporary measure to ensure the safety of those in the Sikalari area and to ensure that the aid is delivered to civilians in need. The basis, Your Honours, was upon the fact that they could not assure that the FNA would not accrue some military advantage, nor could they assure that aid actually reached the civilians of Sikalari.
Is there a citation, some case law, which supports this view that if there is some misappropriation, that you can halt all supplies?
Well, Your Honours, we refer to the case concerning the military and paramilitary activities in and against Nicaragua, where it was considered that the provision of humanitarian assistance only must be limited to the purposes in that particular circumstances. They evidence the case of the Red Cross, which is to prevent or alleviate human suffering and to protect life and health and to ensure respect for the human being. What it creates is an obligation that it must be solely humanitarian and impartial in nature, and this was moreover approved in the learned commentary to the section of Article 70. And what this amounts to is that where there is a doubt as to the legitimacy of the passage of this humanitarian aid, that it cannot be given free passage or accorded the protections of free passage. And in fact, the fact that the BDF did permit the aid convoys to enter Sikalari, even where there was this doubt, shows that they were going above and beyond their duty and their legitimate right to refuse under humanitarian law. In turning then to the issue of the lack of appreciable improvement, we would state that this goes towards a finding that the denial of aid would not have led to starvation, as supplies were not reaching the civilians in either circumstances. Your Honours, this goes towards the mental element of the willful deprivation, and we would turn then to addressing that submission. Your Honours, even if it was considered that impediment did occur, that there was deprivation, it was not willfully done. Willfulness must be intentional or reckless, and in the present circumstances, as all interference with the free passage of relief was justified under the Geneva Convention's Article 23 or 70, there was no intention on the part of the Grunitian forces to actually impede the supplies.
Why do you say that it was justified to stop all aid going in because fuel was being misappropriated by the enemy? Why wasn't your client under an obligation to allow at least food and water through?
Because, Your Honour, they could not assure that the supplies, once they entered Sikalari, would actually reach the civilian population. And for that we refer to the facts that the FNA was seen to be selling those relief supplies on the black markets, and the Humanitarian Observatory report that the supplies were not making any appreciable difference. And we would draw distinction in relation to this in the case of al-Bassiouni in the High Court of Justice in Jerusalem in Israel. They considered the restricting of fuel supplies to civilians within the Gaza Strip on the basis that insurgents of the terrorist group Hamas were interspersed amongst them. And it was considered that a basic humanitarian need could be met by the provision of some fuel supplies, of some electricity supplies. And this would go towards powering hospitals and schools, because they would know and be able to refine where that power would be directed towards. In this case, they do not have the capacity to assure themselves that it will not be appropriated by the enemy forces. They have evidence that anything that they send in will be given to the FNA and will not actually reach the civilians of Sikalari. And in such circumstances, where they cannot assure that the civilians will be the exclusive and sole beneficiaries of that aid, they are entitled to refuse that aid and to seek, as they stated in their declaration as to why they suspended the aid, some other measure to ensure that the civilians were getting relief supplies.
Doesn't that involve an acceptance on the accused's part that civilians would starve?
Well, Your Honour, with respect, in relation to this war crime, intention, it turns on only intention to cause starvation, and it is not, therefore, there is no consequence requirement to this crime. And even if the elements of crime themselves were ambiguous, we would rely upon Dorman's respected commentary, which states that the PrepCom agreed that no requirement as to the result of the accused acts, that one or more persons died from starvation. We only look to the mental intention on the part of the parties, that whether or not they intended to use starvation as a method of warfare. And in response to that, Your Honour, the question would then be whether they did intend to use such starvation. And in relation to that point, we would note that the conduct of the Brunician forces demonstrates an intention, never demonstrated an intention to deliberately weaken the population as distinct from the Flylandian National Army within them. And they sought always to ensure that aid actually reached the civilians as opposed to the Flylandian army. In the present circumstances, whereas stated the majority of the aid supplies appeared to be misappropriated and were benefiting the Flylandian National Army soldiers, the Brunicians' actions in preventing supplies was indirectly affecting the Flylandian National Army's ability to operate and ability to reap a benefit from these relief supplies, as distinct from denying the civilian population as a whole. Where the supplies were not reaching the civilian population, but rather the soldiers amongst them, denying those supplies is hurting the FNA and not the civilian population, and it cannot be seen to be an intention to use starvation against the civilian population, but only against the Flylandian National Army. The final issue for consideration is whether, in the event the court is not with us as to the elements of crime, the General Bird does not incur command responsibility under Article 28. In regards to this element, we rely upon the case of Prosecutor Mbemba being the leading judgment in this area. Responsibility will arise where the suspect is a military commander who had effective command and control over the perpetrating subordinate forces, where the crimes committed by the forces resulted from the suspect's failure to exercise control properly over them, where the suspect either knew or had reason to know that the forces were committing or about to commit the crimes, and finally, that the accused failed to take the necessary and reasonable measures within their power to prevent or oppress the commission of those crimes. As regards the first and second elements, the defence accepts that at all relevant times, General Byrd was the de jure military commander of the BDF and the de facto military commander of the Lines of Aquas. However, merely holding a de jure position is not sufficient without substantial additional evidence to prove that General Byrd had effective control over the Brunician forces. Your Honours, the case of Prosecutor Mbemba provides an illustration of where and how effective control may be proven. In that case, Mr. Bemba, who held an equivalently superior position to General Byrd, had the power personally to order the punishment of soldiers for breaches of their own internal rules, being pillaging in the relevant circumstances. And in response to our learned friend's submission that this power of superiority proves prima facie that there is effective command and control, as noted in the appeals chamber in Celabici, they rejected the prosecution's submissions that even though one could be argued that arguably effective control may be achieved through substantial influence, a demonstration of such powers of influence will not be sufficient in the absence of showing the material ability to prevent and punish. What we press, Your Honours, is that there is a difference between having substantial power and control and having the ability to prevent and punish crimes. And we would submit that nowhere on the facts does it state that General Byrd has this capacity to prevent or punish crimes, and as such, effective control cannot be established.
Can't we infer that that he's got that power from his position in the Defence Force? He heads it up.
Sorry, no?
He's the head of the Defence Force. Can't we infer that he has the power to discipline his soldiers?
Not necessarily, Your Honour. There may be a separate judicial wing to the military branch, and all we have on the evidence is that General Byrd had the capacity to issue administrative orders to the effect of whether or not relief convoys may be allowed to enter into Sikalari. And we once again to refer to the case of Bemba, where it was found that he had the material ability to order the punishing of soldiers in those relevant circumstances.
So is your submission here effectively the prosecution have failed to discharge their onus of proof on this issue?
Yes, Your Honour. In relation to the knowledge element, no, note my time is almost expired. May I have a brief extension to conclude?
Yes, you may.
To briefly address this issue, knowledge cannot be presumed and must be established by way of direct and circumstantial evidence. We would note that though General Byrd was provided with annotated notes of the convoy, he was geographically distant from Sikalari and based at the BDS headquarters. Moreover, Colonels Moran and Funhowe were stationed on site and annotated those notes that he received, thus diluting his effective knowledge of the situation within Sikalari. The question does arise for consideration as to whether he could have been put on notice by the various media reports. We would note that the same was considered in Bemba, where reports of the crimes were repeatedly broadcasted by international news channels such as the BBC and the Voice of America, and in those circumstances, witnesses attest to the fact that Mr. Bemba regularly read and listened to press reports in relation to the conflict. In contrast, the present circumstances, the local newspaper of Sikalari cannot have been expected to have been read by General Byrd, being a geographically confined and distant location to him, and the media reports, even if considered by General Byrd, contained only evidence, firstly, that aid was not entering Sikalari, and secondly, that civilians were dying, regardless of the fact that aid was entering and that he knew that he had approved aid in any case. It was sufficient to put him on notice that there was something wrong with the humanitarian convoys, that they were not impartial, that they were being appropriated, and as such, there was nothing within this to give him knowledge that there was an intention to starve. If Your Honours have no further questions, I would defer to my learned junior in relation to count 2.
Just one little one. You referred earlier to the reports from the Human Rights Organisation Observatory, and relied upon those reports for General Byrd's understanding of the situation, and yet now you're saying that he didn't necessarily need to have that understanding of the situation because he's geographically located a long way away, and yet earlier you're relying on the fact that he's using those reports to know about the situation.
Apologies,
Which way is it?
I would clarify that we would say that it would not be just for General Bow to rely on his ignorance or incompetence to take note of these Human Rights Observatory reports, but in the present circumstances, if we look to the actual content of those reports, they do not go towards suggesting that a crime is taking place, but merely to the fact that the nature of the humanitarian aid entering into Sikalari is not legitimate, that it is not providing an actual benefit to the civilian population, but that it is being misappropriated. The actual content of those reports was firstly that aid was entering but not causing an improvement, and secondly that civilians were dying as a result of this. And that would put him only on notice that the humanitarian convoys were in some way impartial and not benefiting civilians.
Thank you, Ms Bunting.
May it please the Court.
Yes, Mr Bowes.
Thank you, Your Honours. May it please the Court, Your Honours. The prosecution has not proved beyond reasonable doubt that Professor Klaus is responsible for the war crime of excessive incidental death, injury or damage under Article 3(1) Roman numeral 3 of the Tribunal Statute. It is a tragedy that civilians were injured and killed. The defence does not in any way seek to minimise the significance of this tragedy. However, the fact that a tragedy occurred does not entail that a war crime was committed, much less that Professor Klaus is individually responsible for that crime. The defence submits that in the present case there was no war crime, but rather a legitimate attack in furtherance of the war between Brunicius and Flyland. And alternatively, that if there was a war crime, that this war crime is attributed solely to the students and not to Professor Klaus himself. Your Honours, we adopt our learned friend's submission that Article 8 2b4 of the ICC Elements of Crimes outlines 5 elements which must be proved beyond reasonable doubt. And we note that a 6th element of intentionally launching the attack arises from Article 8 2b4 of the Rome Statute itself.
Do you say that each individual element must be proved beyond reasonable doubt before a conviction can be recorded, or is it sufficient if overall the tribunal is satisfied beyond reasonable doubt of the commission of the offence?
Your Honours, as the commission of the offence involves the commission of each and every element contained within the Elements of Crimes and the Rome Statute, the submission of the defence is that all 6 elements must be proved beyond reasonable doubt before the tribunal can enter a conviction against Professor Klaus.
Thank you, Mr Bowes.
Thank you, Your Honours. Your Honours, the defence contests all elements except the 4th and 5th elements in respect of the existence of an international armed conflict. Your Honours, the prosecutor did not allege in their written submissions that Professor Klaus committed the crime, nor did they allege that Professor Klaus aided and abetted in respect of the commission of the crime. These are fresh allegations that have been brought before the court today, but in any event, the defence submits that the elements of these modes of liability are not fulfilled. I will make 5 submissions today. First, that the attack was limited to the launching of a missile against a school. Second, that it was only intended that an attack would be launched against the school. Third, that the attack was not such that it would cause clearly excessive death, injury or damage to civilians. Fourth, that it was not known that the attack would cause such damage. And fifth, that even if a war crime was committed, Professor Klaus did not commit, aid and abet, and does not bear superior responsibility for this attack.
Counsel, could I just ask you then, you're talking about the attack against the school and saying that there was only ever an intent to attack the school.
That's correct, Your Honour.
So in paragraph 15, when the team continued to fly the drone towards one of the largest army bases, there's no intent there to do anything.
Allow me to clarify, Your Honour, there was an intent to attack the army base, but we submit that as the army base was a legitimate military objective, that no liability arises from the attack upon this base, and that separately it must be considered whether there was an attack launched against the village and whether it was intended that an attack would be launched against the village. I turn to our first submission, that the attack was limited to the launching of a missile against the school. Article 49.1 of Additional Protocol 1 defines attacks as acts of violence against the adversary. As the drone was used to launch a missile against the school, this constitutes an act of violence, but the drone was not used by Professor Klaus or his students to launch an attack against the village. The defence therefore submits that no act occurred in respect of the launching of a missile against the village, and therefore that the attack was limited to the launching of a missile against the school.
Why do you say that that attack against the school was proportionate?
Your Honours, we submit that the attack against the school was not, or rather, just to clarify, the test is that it was not clearly excessive in relation to the direct and concrete military advantage anticipated. And in respect of this, we refer to footnote 36 of the ICC Elements of Crimes, which states that this element applies IHL's proportionality standard. Your Honours, the Gallich trial judgment, paragraph 58, clarifies that this is assessed prospectively from the perspective of a reasonably well-informed person in the position of the actual perpetrator. It does not ask what damage actually occurred, but of the damage that would occur, and does not ask what Professor Klaus subjectively thought, but what a reasonable person in his position would have thought. Your Honours, the prosecutor alleged that this balance should be resolved in favour of the prosecution, but the defence submits that in fact it must be resolved in favour of the defence, in light of Article 22.2 of the Rome Statute, which provides that crimes must be strictly construed and that any ambiguity in the definition of a crime must be resolved in favour of the defendant. Crucially, it is not enough that the attack could possibly cause damage. The words of Article 21.1a of the Rome Statute and of the Elements of Crimes, or rather 21.1a of the Rome Statute requires that in the first place this court apply the Rome Statute and the Elements of Crimes, and the word used in both of those instruments is that the damage would cause the attack. It is confirmed in Article 32b of the Rome Statute that in relation to a consequence, what is required is an awareness that the consequence will occur in the ordinary course of events. The defence submits that death or injury to civilians would not have occurred in the ordinary course of events in attacking the school. The school was not a civilian object, as it was being used to shelter 150 FNA soldiers. It is true that a person was required to verify, or rather to do everything feasible to verify, that civilians would not be attacked. However, there is no war crime of merely failing to verify that civilians will not be attacked. The failure to verify is only relevant insofar as it affects what a reasonably well-informed person would have known. And so if the failure to verify would have made no difference, then it is not relevant to the assessment of proportionality in the present case.
Would not a reasonably well-informed person have known that the population of this town had been increased from 10,000 to 30,000 by the influx of, in effect, internal refugees, and that a school was very likely to be used by those internal refugees as a place of shelter?
Your Honours, they would certainly have known that there were bombings occurring in the state of Flyland, but we submit that the survivors of these bombings could have fled to any location in Flyland. There is no evidence to suggest that in response to the bombing of a nearby area, that these survivors fled to this particular school. And therefore, any feasible attempts that a person had taken in respect of attempting to verify that civilians would not be attacked would not have made any difference.
Council, can I just go back to, you use the term ordinary course of events. We are talking about wartime here.
Yes, Your Honour.
And in the ordinary course of events in a war, surely it must have come within Professor Klaus's mind that civilians would shelter within a large municipal building when there's been bombing a few nights before, that wouldn't be beyond the ordinary course of events in this kind of situation.
Your Honours, in respect of this element of the crime, the question is not what Professor Klaus knew, but rather what a reasonably well-informed person in his position would have known. And when an entire state is at war we submit that a reasonably well-informed person cannot be expected to know that civilians are sheltering in any particular building, particularly when that building is a military objective as it is being used to shelter soldiers.
But it is also a school
Yes, Your Honour.
to the civilians.
Yes, Your Honour. Certainly prior to the beginning of the war in Flyland, the use of this building was a school. But following the initiation of the war in Flyland, it had been transformed into a military objective by the entry of soldiers into this building, using it as a shelter. And there are no facts to establish that it was continuing to be used as an educational facility. And indeed, if it was, this would clearly fall foul of Flyland's obligation under Article 58A of Additional Protocol 1 to remove civilians from the vicinity of military objectives.
Is your argument that the accused could assume that Flyland would have complied with that obligation?
No, Your Honours, that's not the defence submissions. Rather, in respect of what Professor Klaus or the students subjectively knew, we submit that they nonetheless remained under their obligation to verify that civilians would not be attacked. But the mere failure to conduct this obligation does not amount to subjective knowledge on their part that civilians were sheltering in that school, and that it is a reasonable inference for this tribunal to draw that Professor Klaus and the students did presume that civilians had been removed from the military base and therefore did not know that civilians were sheltering in the school.
Thank you.
To return to the objective element for one moment, that it was not established that the damage would be clearly excessive, we submit that as a reasonably well-informed person would not have known that civilians were sheltering in the school, that a reasonably well-informed person would not have anticipated that any civilian death or injury would have resulted from an attack upon the school. Your Honours, consequently, no military advantage was required in the present case. But despite this, the defence submits that there was a significant military advantage flowing from the fact that the school was being used to shelter 150 FNA soldiers, and consequently that an attack on the school would have been expected to kill or injure its soldiers. As there was no, or rather as the attack was not such that it would cause any civilian death or injury, and as the anticipated military advantage was significant, the attack on the school was not clearly excessive in relation to the direct and concrete military advantage anticipated. I turn to our fourth submission, that it was not known by Professor Klaus or the students that the attack was such that it would cause clearly excessive death, injury, or damage. Footnote 37 of the Elements of Crimes states that this element requires that the perpetrator make a value judgment. The committee established to review the NATO bombing campaign noted at paragraph 28 of its final report to the prosecutor that the reckless refusal to judge is sufficient, but that negligence is not. Your Honours, I have already established that Professor Klaus and the students did not personally know that civilians were present in the school, and therefore they could have not have known that any death or injury to civilians would result. In respect of the military advantage that they would have anticipated, it is stated at paragraph 12 of the facts that the students were a carefully selected group who received special training in cyber warfare. The intended targets of their attacks were, in the first instance, the school which was being used as a shelter for 150 FNA soldiers, and in the second instance, one of the FNA's largest army bases. In light of these facts, it was likely that a significant advantage would accrue from the attacks in the present case.
Can we draw any inference adverse to your client on the basis that he knew of the occupation of the school by the opposition's armed forces, but you say he didn't know the occupation of the school in part by civilians?
Your
How
Honour's,
do you know one and not the other?
I understand Your Honour's concern, but in the present case, the school was being used as a military shelter over a significant period of time, whereas paragraph 14 of the facts state that civilians were only present in the school, and I quote, for one night, as a result of the bombing in the nearby area. And so it is reasonable for this tribunal to infer that Professor Klaus was aware of the long-standing use of the school as a military shelter for FNA Army soldiers, but that there was no way that Professor Klaus or the students could have known that students were merely there for one night by circumstance, and that any feasible attempts at verification would not have brought this to their attention.
Thank you, Mr. Burrows.
Thank you, Your Honours. Your Honours, as Professor Klaus or the students could not have known that students were sheltering in the school, and as they would have anticipated a significant military advantage, we submit that the most reasonable inference is that Professor Klaus or the students did judge what would occur in the present case and judge that the attack was not such that it would be clearly excessive in relation to the expected military advantage. Your Honours, I turn to our fifth submission, that even if a war crime occurred, that Professor Klaus is not personally responsible for this crime. Article 7.1 of the Tribunal Statute outlines the modes of liability by which a person can be held criminally responsible for a crime. As this is identical to Article 7.1 of the ICTY statute, the case law of the ICTY is of the greatest assistance to this tribunal in interpreting Article 7.1 of the Tribunal Statute. Your Honours, the prosecution has alleged today that Professor Klaus physically perpetrated the crime, alternatively, that he aided and abetted in the commission of the crime, and alternatively, that he bears superior responsibility as a result of his position of superiority over the students. In respect of physical perpetration, we note that although Professor Klaus worked for 2 months in order to hack the FNA's drone network, there is no evidence of the use of this drone at a later time in order to launch attacks against the school and against the village was anything other than the student's own spontaneous act.
Excuse me, counsel. In paragraph 14, it does actually say that the professor, with his team, launched one of the missiles directed at the school. How do you overcome the fact that the facts appear to say that he launched the missile?
Well, that's correct, Ron. The facts do state that it was the team that launched the missile, but the facts do not divide up who took what actions in respect of any event that was occurring at that point in time, and consequently do not prove beyond reasonable doubt that it was Professor Klaus as opposed to any of his students who launched the missile. In the alternative that Your Honours are not with us in respect of the school, we submit that the attack on the village can be attributed to the students and not to Professor Klaus, and in particular, note at paragraph 15 of the facts that it states that Professor Klaus attempted to steer the drone away from the village, and so insofar as any act is attributable to Professor Klaus in relation to the further attacks, that action is one of attempting to prevent the attack from occurring and not one of participation in the attack. As the defence submits that the attack on the school was a legitimate military attack, Professor Klaus's participation in this crime, or Professor Klaus's participation in these events would not constitute a war crime in any event in the submission of the defence. Your Honours, in respect of aiding and abetting, the prosecutor notes, or rather the defence notes, at the Tadich appeal judgment, that the material element of aiding and abetting is that a person carries out acts specifically directed to assist, encourage, or lend moral support to the crime, and that this has a substantial effect upon the perpetration of the crime. In the present case, it is not proved that Professor Klaus did anything in respect of the use of the drone to attack the school or the village, let alone that anything Professor Klaus did do was such that it had a substantial effect upon the perpetration of the crime. The mental element of aiding and abetting is provided for by the Tadich appeal judgment at paragraph 229. Your Honours, I note that my time is about to expire. May I have a 1-minute extension to complete this submission and to sum up my submissions?
Can I just ask how much time you would have had if you hadn't asked for the extension?
I would have had 19 minutes.
No, how much time it remains?
Oh, 30 seconds, Your Honours.
Oh, is it right?
Yes.
Yes.
Thank you, Your Honours.
Yes, that's fine.
An extension of 60, another
Yes,
minute?
there's one on top of that.
Another minute, yes. Thank you, Mr Bowes.
Thank you, Your Honours. The mental element of aiding and abetting is knowledge that the acts assist the commission of a specific crime. The defence submits that Professor Klaus did not know that the students were engaging in anything other than a legitimate attack upon the school, and consequently, that even if Professor Klaus did participate in some act to assist with the commission of that attack, that Professor Klaus did not know that it would assist with the commission of a specific crime. Consequently, Your Honours, Professor Klaus does not incur criminal responsibility for any war crime that may have occurred. In conclusion, Your Honours, the defence submits that the prosecution has not proved beyond reasonable doubt that Professor Klaus or General Bird are guilty. We therefore respectfully ask this tribunal to acquit General Bird and Professor Klaus of all charges. If Your Honours have no further questions, those are the submissions to the defence.
Thank you, Mr Bowes.
Thank you, Your Honours.
Will we give our feedback now?
No, I think they may have rebutted, so we'll see if they can do that.
Mr Campbell, do you wish to exercise your right of rebuttal?
Yes, the prosecution will be exercising its right to rebuttal. Just with reference to the rules, is it permissible for the junior counsel to rebut?
It's not stated explicitly otherwise.
We're unanimous in the opinion that it is permissible.
Our junior counsel.
You are burdened with that task, Ms Vincent.
Your Excellencies, in addressing count 1, the prosecution will make one point of rebuttal. The learned senior counsel for the defence has argued that the unsubstantiated concerns that individual aid convoys would not of an impartial nature justified the BDF's total refusal of aid for a period of 3 weeks. However, while we acknowledge the rights of the BDF to legitimately regulate the passage of aid, the wording of and commentary to the articles of additional protocols referred to by my learned friends affirm that these regulatory safeguards must in no case be misused in order to make the rule that an occupying power must accept aid destined for the population inoperative, as would be the case in the event of the total refusal of aid. This is further affirmed by Article 54B of Additional Protocol 1, which states they must only take such actions as would be expected to leave the population with such adequate food or water as to prevent starvation, which was not the case in the circumstances. Moving to count 2, the prosecution would make 2 brief points of rebuttal. Firstly, that my learned junior counsel for the defence has misquoted the wording of paragraph 14 in stating that the civilians were only sheltering for 1 night. The wording of paragraph 14 states that civilians were sheltering for the night, and consequently the likelihood that civilians had been there during night time in the several days since the bombing had occurred should be considered by this tribunal and would have been known by Professor Klaus at the time. Finally, much of the defence's arguments rests on the idea that the failure to verify or take any precautions in judging the excessiveness of loss does not affect Professor Klaus's criminality. However, on the contrary, as was established in note 109 of the judgment of Tadic and the prosecutor, while negligence is not sufficient, a reckless failure to judge will be sufficient to establish liability. Your Excellencies, these particular actions may have been negligent in the circumstances for an ordinary civilian. However, this complete failure to take precautions mandated by Articles 57 of Additional Protocol 1 on the part of the former head of the Defence Network of the BDF's Technical Centre in control of inexperienced personnel and dangerous weapons, this was a reckless failure to judge and should be sufficient. If the tribunal have no further questions, concludes our submissions.
Thank you, Ms Vincent. Ms Bunting, do you wish to exercise your right of rebuttal?
If you are still unanimous in your opinion that it can be deferred to the learned junior, I would do so as well.
We certainly would not differentiate between the two. Yes, thank you, Mr Bowes.
Thank you.
Thank you, Your Honours. May it please the Court, Your Honours. the defence makes one submission in rebuttal, namely that recklessness is not the mental element for the attack of causing excessive incidental death, injury or damage to civilians under Article 8, 2b4 of the International Criminal Court's Elements of Crimes. Your Honours, the Elements of Crimes outlines two subjective mental elements that must be fulfilled in order for the crime to be established. The first, that the perpetrator intended to launch the attack, and the second, that the perpetrator knew that the attack was such that it would cause excessive incidental death, injury or damage to civilians. We submit that these two elements cannot merely be conflated to form a single element of recklessness, but rather that it remains for the prosecution to prove each of them separately beyond reasonable doubt, and that for the reasons we gave in our primary submissions, the prosecutor has not proved that the attack was intended to be launched against anything other than the school, or that Professor Klaus or the students knew that the attack was such that it would cause clearly excessive incidental death, injury or damage. May it please the Court, those are the defence's submissions and rebuttal.
Thank you, Mr. Bowes.